The neighborhood had always been quiet in that carefully manufactured way only an HOA community could manage. Lawns were trimmed to identical lengths, trash cans disappeared within minutes of pickup, and no one parked even an inch over the invisible boundaries painted by unspoken rules. It was the kind of place where silence felt enforced, not earned. For years, that order worked just fine, mostly because nothing truly challenged it. That calm began to crack the moment the new neighbor moved in. At first, the arrival seemed harmless. A large moving truck blocked half the street for hours, followed by a steady stream of unfamiliar vehicles. Furniture, boxes, random equipment, and oddly shaped items were unloaded with little concern for space or courtesy. It was annoying, but still within the realm of tolerable inconvenience. New people always made a mess before settling down. At least, that was the assumption. Then the driveway issue began. The driveway in question was clearly marked, legally owned, and part of a property that had never once been disputed. It had always been empty except for the owner's own vehicle. One morning, a stack of boxes appeared near the edge of it. By the next day, those boxes had multiplied and crept further inward. Soon after, large items followed. Shelving units. Plastic bins. Rolled carpets. Random household clutter stacked as if someone had decided that the space was suddenly communal. It felt surreal at first, like a mistake that would correct itself. Surely the neighbor would realize the error and move everything back onto their own property. That never happened. Instead, the pile grew. Photos were taken. Dates were noted. Property lines were double-checked. Nothing about the situation was ambiguous. The driveway was private, and the use of it was unauthorized. That should have been the end of it. But HOA communities thrive on technicalities, not common sense. A formal complaint was submitted to the HOA, complete with evidence. The expectation was simple: the association would enforce its own rules and instruct the neighbor to remove their belongings. After all, unauthorized use of another homeowner's property was a clear violation. Or at least it should have been. The response that came back was short, cold, and shocking. The HOA decided that the neighbor's use of the driveway was temporary and non-disruptive. They suggested patience. They suggested understanding. They suggested tolerance. According to them, no immediate action was necessary. That decision changed everything. What had once been an inconvenience now felt like an endorsement. The neighbor, emboldened by the HOA's refusal to intervene, escalated. Larger items appeared. Heavy items. Things that were clearly not meant to be moved daily. It no longer looked like temporary storage. It looked permanent. The driveway became unusable. Parking was impossible. Access was blocked. The simple act of pulling in or out became a daily reminder that ownership meant nothing when authority chose to ignore it. Every morning, the sight of someone else's possessions sitting comfortably on private property sparked a new wave of frustration. Another complaint was filed. This time, the HOA doubled down. They referenced vague clauses about shared harmony and neighborly compromise. They implied that pushing the issue further would be considered disruptive behavior. The problem was no longer the neighbor's actions. The problem, apparently, was the refusal to accept them. That was the moment the tone shifted. The realization settled in that the HOA was not neutral. They had chosen a side. And it wasn't the one that involved property rights or fairness. The rules that had been enforced mercilessly for minor violations suddenly became flexible when enforcement was inconvenient. And if the HOA was willing to redefine ownership, then maybe ownership itself needed to be re-examined. A careful review of HOA bylaws, local property regulations, and abandoned property laws began. Not out of spite, but out of necessity. If the neighbor was allowed to place items on someone else's driveway without consequence, then what exactly did that imply legally? The answer was both surprising and empowering. There was no written permission. No lease. No agreement. The items left on the driveway were, by definition, unauthorized and unattended on private property. In many jurisdictions, that crossed into a gray area where responsibility shifted. The HOA had unintentionally opened a door. What started as annoyance evolved into strategy. If the neighbor believed they could claim the driveway as storage because the HOA allowed it, then perhaps the items stored there were also subject to interpretation. After all, responsibility follows ownership, and ownership had been ignored entirely. The situation was no longer about politeness. It was about precedent. More items appeared, almost daring intervention. The neighbor behaved as though the driveway was now an extension of their own home. No warning. No explanation. Just entitlement reinforced by silence from those meant to regulate it. That silence became permission. And permission, once given, could be used in unexpected ways. The decision wasn't impulsive. It wasn't emotional. It was calculated. If the HOA refused to act, then action would come from somewhere else. Not through confrontation, but through compliance with the very logic the HOA had embraced. If the driveway was fair game, then so was everything on it. The first step was preparation. The second was patience. And the third would change the entire dynamic of the neighborhood. Because when rules stop protecting the right people, the rules themselves become tools. And the moment the neighbor realized their assumption had consequences, the story would shift from quiet frustration to full-scale HOA chaos. Once the decision was made, everything became quiet again, but this time, the silence felt controlled. The driveway still sat occupied by the neighbor's belongings, stacked confidently as if they had always belonged there. To an outsider, nothing had changed. But underneath that stillness, the situation had shifted completely. This was no longer about asking. It was about using the same logic the HOA had forced into existence. The first step was to document everything again, not as a complaint this time, but as proof of abandonment. Photos showed how long the items had remained untouched. Days turned into weeks. Dust settled. Rain stained cardboard. Plastic faded in the sun. Nothing moved. Nothing was retrieved. No effort was made to pretend the items were temporary. According to local property regulations, unattended items left on private property without permission fell into a very specific category. Responsibility for them no longer rested with the person who placed them there, it shifted to the property owner. That included the right to remove, relocate, or dispose of them. The HOA's refusal to intervene had unintentionally validated this condition. If the neighbor wanted to treat the driveway like free storage, then the items on it would be treated like unclaimed property. The first removal happened early in the morning. Not out of secrecy, but efficiency. Smaller items were cleared first. Loose boxes. Broken furniture. Things that clearly held little value but took up space. They were moved off the driveway entirely, placed into temporary storage where they could be sorted properly. Nothing was damaged. Nothing was hidden. Everything was handled with deliberate care. The driveway, for the first time in weeks, had visible space again. That didn't last long. By the end of the day, new items appeared. Larger ones this time, as if the neighbor were testing boundaries. The behavior felt deliberate now. A silent challenge. An assumption that no one would dare interfere. But the assumption was wrong. Each time items appeared, they were logged, dated, and removed. The process became routine. No confrontation. No notes. No warnings. Just consistent action. The driveway remained usable, and anything placed there without permission was treated the same way. The neighbor noticed. The escalation was immediate, though indirect. Complaints were filed, not to the homeowner, but to the HOA. Claims of missing property. Accusations of harassment. Emotional language filled with outrage and disbelief. The neighbor couldn't understand how their belongings kept disappearing when they had been allowed to store them there. The HOA responded quickly this time. A notice arrived accusing the homeowner of overstepping, of creating conflict, of failing to maintain neighborhood harmony. The irony was almost impressive. The same organization that had ignored unauthorized storage was now furious about its consequences. A formal response was prepared. It included every photo, every date, every previous complaint. Copies of HOA emails acknowledging the driveway issue and dismissing it as non-problematic. Local statutes outlining abandoned property rules were attached. The tone was calm, factual, and devastatingly thorough. There was no accusation. Only logic. If the HOA believed the neighbor's use of the driveway was acceptable, then the homeowner's management of items left on their own property was equally acceptable. Either property rights mattered, or they didn't. The HOA couldn't selectively enforce reality. One, however, came with an unexpected twist. The neighbor demanded legal action. They claimed theft. They claimed damages. They claimed emotional distress. The situation had officially left the realm of passive aggression and entered something far more serious. Preparation intensified. Receipts for storage services were collected. Documentation showed that removed items were preserved, not destroyed. Notices were drafted explaining how and where the items could be reclaimed. Everything followed procedure. No shortcuts. No emotional decisions. When the hearing day arrived, the atmosphere was tense. The HOA board sat rigidly, already defensive. The neighbor arrived visibly furious, carrying entitlement like a shield. They expected support. After all, they had been allowed to do whatever they wanted for weeks. That expectation unraveled quickly. Evidence was presented in chronological order. The story told itself. The HOA's own emails contradicted their current stance. The neighbor's behavior looked less like a misunderstanding and more like calculated misuse. The board realized something dangerous: their inaction had created liability. The hearing ended without resolution. Instead, the HOA passed the problem upward, suggesting legal mediation. That suggestion alone was enough to trigger the next explosion. The neighbor pushed for court involvement, convinced that a judge would see things their way. They were certain the system would protect them. They were wrong. Because court doesn't care about HOA favoritism. Court cares about documentation, timelines, and property law. And all three were finally aligned. As the court date approached, the neighbor's confidence began to crack. Demands turned into frantic emails. Accusations turned into bargaining. The same person who once acted untouchable suddenly wanted compromise. But compromise only exists before consequences. By the time the courtroom doors opened, this was no longer about a driveway. It was about entitlement colliding with reality, and the fallout was going to be very public. By the time the court date arrived, the energy surrounding the dispute had shifted completely. What once felt like a simple neighborhood annoyance had transformed into a formal legal matter, with real consequences and no room for emotional narratives. The courtroom did not care about assumptions, favors, or informal permissions. It cared about facts. And the facts were devastatingly clear. The timeline was laid out methodically. Property ownership documents established the driveway as private. HOA correspondence showed repeated requests for intervention and repeated refusals to act. Photographic evidence documented the gradual takeover of the driveway, the duration items remained untouched, and the consistency of their unauthorized placement. Every step of removal was accounted for, logged, and supported by applicable local statutes. The neighbor's case, in contrast, relied almost entirely on outrage. They framed the situation as betrayal, as unexpected hostility, as an attack on goodwill. They spoke about trust, about neighborly expectations, about how the HOA had made them feel protected. What they could not produce was a single document granting permission to store anything on someone else's property. The HOA's presence in the courtroom was uncomfortable. They were no longer referees. They were witnesses to their own inaction. Their earlier decisions were now evidence, not authority. The same language they had used to dismiss the problem, temporary, harmless, non-disruptive, was turned back on them under scrutiny. Temporary, the judge noted, does not mean indefinite. Harmless does not mean consequence-free. The abandoned property statutes were decisive. Items left unattended on private property without consent fell under the responsibility of the property owner after a reasonable period. Removal, storage, and even disposal were legally permissible when due process was followed. And due process had been followed carefully. The neighbors' argument began to unravel. Their emotional reactions escalated as the legal foundation collapsed. The certainty they once carried dissolved into visible panic. The realization hit them all at once: the protection they thought the HOA provided did not exist in a courtroom. The judge's ruling was precise and unambiguous. The homeowner had acted within their legal rights. The neighbor had no claim to damages. The HOA was formally warned about selective enforcement and reminded of its obligation to respect property boundaries. Any remaining items would need to be reclaimed under strict conditions, including reimbursement for storage and handling. The reaction was immediate. The neighbors' composure shattered. What had been quiet entitlement turned into open disbelief. Their attempt to dominate the situation through pressure and assumption had backfired spectacularly. In trying to claim something that was never theirs, they had lost both credibility and leverage. The HOA left the courtroom shaken. Back in the neighborhood, the impact was undeniable. The driveway remained clear. The neighbors' belongings were removed for good. The unspoken hierarchy of favoritism collapsed under the weight of legal accountability. Word spread quickly. Other homeowners began revisiting old grievances. Previously ignored complaints resurfaced. The HOA, suddenly aware of its vulnerability, shifted behavior almost overnight. Rules were enforced consistently. Warnings were issued evenly. The quiet tyranny of selective enforcement lost its grip. The neighbor became isolated. Not through confrontation, but consequence. Their presence no longer carried authority or assumption. They avoided attention, aware now that entitlement had a cost. The driveway they once claimed as storage stood empty, a silent reminder of a line crossed and corrected. What made the outcome powerful wasn't revenge. It was precedent. The story wasn't about taking someone's belongings. It was about reclaiming boundaries. About understanding that silence from authority does not override ownership. About recognizing that compliance with unfairness only enables it. The driveway became what it always was meant to be: private, respected, and undisturbed. And the HOA learned a lesson it could never ignore again. Because when rules are bent for the wrong reasons, they don't disappear. They snap back. Hard.